Welcome everyone to Current in 30, the 30-minute webinar series brought to you by the Current Consulting Group. We are thrilled to have you with us. To briefly introduce this series, each session is designed to keep you informed, efficient, and ahead of the curve. On the second and fourth Mondays of each month throughout 2026, we'll break down key things you need to know about workplace drug screening, from emerging trends and regulatory updates to best practices and practical implementation tips. If you missed our previous sessions, please visit our website, currentconsultinggroup.com, or our YouTube channel at Current Consulting Group to view those sessions. Thank you for joining us today. I'm Greta Walsh of the Current Consulting Group, and today's presentation is titled Current in 30, the importance of reasonable suspicion awareness and drug testing in the workplace. This presentation qualifies for half of a professional development credit from SHRM and HRCI for those who attend today's presentation in its entirety. And now it's my pleasure to turn it over to our presenter, Brian Feely from the Current Consulting Group.
Thank you, Greta, appreciate it. And hello everyone, and thanks for attending this Current in 30 webinar. The series is really turning out to be quite impactful, and we're getting some good comments back. So, thank you for attending, and please let us know if there's specific topics you'd like us to address in the future. Today's presentation, I think, is an interesting one because we see more and more inquiries coming in about reasonable suspicion testing and reasonable suspicion in general. I think it's becoming an even more important part of people's policies and programs. And so we'll touch on that, and I'll go through the agenda in a second. Just briefly who I am, I'm a Senior Vice President at Current Consulting. I've been here for about 3 years now. And prior to that, I spent about 40 years in the diagnostics field, working on really two different aspects of my career. One, technical, and working in a lab, actually developing tests for drugs of abuse and other entities, and doing laboratory work. And then I got into sales and marketing and business development about halfway through my career, and spent a lot of time working on oral fluid drug testing and at a company called OraSure Technologies, and spent about 26 years there on the overall sales and marketing of oral fluid drug testing. So good background kind of on drug testing in general, both from the technical standpoint as well as the practical standpoint of marketing it and implementing it in the field. And more recently have become very involved with the Current Consulting Group's compliance services and what we offer to the industry, which I'll touch on in a second, just to give everybody a little bit of a highlight of what we do. So today's presentation, I'm going to touch on a number of things related to reasonable suspicion testing, primarily these three areas: the overall role that supervisors play, what reasonable suspicion really is, and how it should be documented, and then we'll talk a little bit about some of the testing scenarios and some positive rates that will show you overall drug testing and how reasonable suspicion rates stand out from the rest of the drug testing. A little bit about the state and federal compliance considerations that you need to be aware of, state laws, and then I'll talk a little bit about some specific methodologies and how those windows of detection for different drugs fall into different categories in terms of how they're ideally suited for workplace drug testing, particularly those that identify recent drug use and potentially even impairment. So the introduction here, kind of go through some things related to why people are actually doing drug testing to begin with and what benefits they're seeing. So every year, Current Consulting Group does 2 surveys. One of them is geared toward providers, companies like TPAs and people that provide drug testing. That's at the beginning of the year, and we just are in the process of doing our 2026 survey for providers right now, as a matter of fact. And then at the end of the year, we do one for employers, really in the fall, and we ask employers a lot of different types of questions. So this data comes from our 2025 survey to employers, and we asked, why they establish and maintain a drug testing program. And in this case, not surprising, as we've seen many years, one of the number one reasons is to promote a safe workplace. 78% responded, and then next comes things like, they have to because of DOT compliance, minimizing legal risks, and another big one is to hire the best possible job candidates. That's very important. When we go to the outcome, so that's why they do it, and this is the benefits that the companies actually are realizing from drug testing, which, not surprising to see, 84% say that they've seen improved safety in the workplace, and that really is key, particularly relative to the topic today. And then you see another big one, 62%, they're able to hire better quality employees, which goes right along with, the reasons that they test. So that's coming to fruition. And then better company reputation, which is really important to a lot of companies. The last one in yellow at the top, or in orange, improved productivity. So that kind of goes hand in hand with, I think, why people want to make sure they're hiring good people, good quality people. Because the better people that you have, the more productive they're going to be, the less time they're going to be out, and less workers' comp issues, et cetera, et cetera. So that all makes perfect sense. Why does your company conduct drug testing? And in terms of the different categories, 94% is for pre-employment, which is not surprising. That's kind of the linchpin of the beginning and then, kind of most important part of having a drug testing program, get them at the front end before they get into your company. 84% though jumps out of here with reasonable suspicion, and then next it's things like random and post-accident testing. So this is kind of a very representative chart of what we hear from people pretty much year over year, and this hasn't changed a whole lot over time, but it's just good to reinforce it. And it's also good to maybe reinforce the fact that while you may think about reducing certain areas of testing, like maybe pre-employment or random testing, it really is an algorithm that fits together. When you start to pull out pieces of your drug testing program and try to do only this or do only that, you're ultimately going to give something up. And so overall, these are the key elements of a good drug testing program, and really, we would suggest they be maintained, throughout the history of your company. All right, so getting to the topic, what is really reasonable suspicion and reasonable suspicion testing? And it's really all about what someone is able to spot in the workplace, and a supervisor is able to take action on that recognition of something that's gone on, and particularly when they think an employee might be under the influence of something. It doesn't always have to be necessarily substances. It could be someone is tired, someone is not fit for duty because of an incident they had at home, and they're just not feeling good, or they're just, they didn't get any sleep the night before. That's also ties into their fitness for duty. Might not necessarily be reasonable suspicion of a drug use scenario, but it still could lead to an incident in the workplace. So just keep that in mind. Keep in mind also that different states may provide a certain guidance as to what constitutes reasonable suspicion. It's not all the same across all 50 states. So you really need to review those applicable laws. And some states may require written documentation of those signs and symptoms in order for you to be taking the next step, which would be, for example, to conduct a drug test. What is for cause testing? So these terms are often used interchangeably. So for cause, reasonable suspicion, kind of one and the same thing. And under the Department of Transportation regulations, they say that it's conducted when a trained and authorized individual observes specific articulable signs that a safety sensitive employee may be under the influence of drugs or alcohol. And so that's their definition, and it's been pretty much adopted, I think, across the industry with some exceptions. But outside of DOT, employers can choose to do their own types of programs, so long as they're compliant with state laws, which we'll talk about in a second. We've got some actual examples within different states of the things to be aware of. But essentially all states do permit for cause testing, and you know, some define what constitutes that, so you just have to be aware of those state laws. Okay, so training of supervisors. And really the purpose is to inform and educate supervisors who might otherwise be reluctant to do something about what they see. We see this in the workplace sometimes when action is not taken by a supervisor. They'll tend to slough things off and maybe just chalk it up as, you know, it's the typical thing that they see from Joe and or George, and they'll let it go, where in effect there really is something going on there, and that behavior could lead to an incident in the workplace. So it's designed to make sure that they're not reluctant, they know what to do, and they know how to address those employees. So they really are responsible for identifying that and determining when reasonable suspicion for drugs and alcohol use may be existing so that they can take the appropriate action. It's also important because many states require companies to conduct that reasonable suspicion testing and provide training to those supervisors. That's in certain laws specifically. The type of training is often referred to as signs and symptoms training. So we'll talk about that in a second. I have a slide on that. And then the policy and subsequent training really describe the supervisor's role, whether it's something that's expected of them or is not necessarily expected of them. And so they need to be able to identify those signs and symptoms, but at the same time, they're not being asked to diagnose a medical condition, for example, or, you know, be able to recommend someone for a, you know, a rehab program or get them into, you know, spot someone that needs to go to AA. That's not their role. The signs and symptoms are many, and they fall into different categories. They could be a physical sign or symptom, or a psychosocial one, or a performance related indicator. I won't go through this whole list, but these are some of the things that we train on in our signs and symptoms courses that we offer, and that people should be aware of, particularly supervisors and managers in the workplace, whether it has to do with their hygiene, the way they're acting, and in particular days that's different from that normal behavior of an individual, whether they're sweating more or shaking, or they look nervous. All of a sudden they're starting to use breath mints, and you see them chewing gum and mouthwash, and some people might even be saying, hey, you know, we're smelling this odor of alcohol from so-and-so, or marijuana. Even more so these days, I think it's more marijuana that people are smelling, either outside in the premises of our communities or even within the workplace. And so they need to be able to spot that. Some of the psychosocial things like mood fluctuations, all of a sudden they're very temperamental and they're easily thrown off from their usual behavior, confused, or they're you know, not interacting as much with their colleagues. And then performance related things, you've got people calling out sick frequently, or they're coming in late more frequently. There's errors that they're committing. These are all things that you need to be watching out for and flagging. And these are all good indicators that provide you with, in some cases, that impetus that you need to say, look, we're going to take this person aside and conduct a drug test. And so this gives you kind of an example of what a supervisor might say. This is just, you know, not any kind of specific language that you need to use, but the things that you need to cover. So you might say to an employee, based on my observation of your behavior and the incident that just occurred, it appears you may be in violation of our company's substance abuse policy. So that number one thing is you're telling them, I've observed something and you may be in violation. You will be required to submit to a drug test and determine if it's safe for you to continue your duties. And that's number two. You've told them that you're going to need to submit to a drug test. And then number three, if you refuse to do that or cooperate with the process, you may be in violation of our company's substance abuse policy and subject to disciplinary action. So that there's, you know, and then getting them in agreement. So there's a couple of key things that you're doing versus just saying, hey, Joe, you smell like pot, let's go do a test. So that doesn't cover it. You haven't told him why, how he smelled, or what the ramifications are, anything like that. It needs to be somewhat detailed. And in some states, you also want someone else to be present when you do this because that way you have a second opinion, and that's required in certain states. And then employee education. You know, many states also require that companies do conduct this for their employees, and it's just a good practice so that people are aware of their program and reasonable suspicion and what's going to happen if that occurs. Keeping both applicants and employees informed about the overall drug testing process, make sure that everybody understands it and avoids that sometimes occurring thing where someone will say, well, I didn't know we had a program, or I didn't know that we drug tested, that no one ever told me. And so, you know, keeping it on the up and up, keeping their supervisors trained, keeping employees aware of the program and what it's there for is really important. All right, so let's talk a little bit about positive rates. And the positive rates in these charts come from the Quest Diagnostics Index. If you've not seen it or used it before, I highly recommend it. It's a publication that comes out every year from Quest, and they have it on their website under their employer services area. And they'll basically give you the positive rates for all sorts of different scenarios for different states. They'll give it to you for different industries, construction versus building versus transportation, et cetera. And they've even added things like oral fluid and hair testing. It's not just about urine anymore. So these two charts, the top one shows for federally mandated safety sensitive workers, what were the different positive rates for the different reasons for testing from 2020 to 2024. And you can see the biggest number jumping out here, for cause or reasonable suspicion, 12.6%. You know, and the overall pre-employment positive rate here of 2.4%. So you see these numbers are quite low because we're dealing with federally mandated employees and DOT employees. So their rates tend to be half or even less than half of what you see in the general workforce, which is what is showing here in the bottom chart. So big difference. You can see for cause testing with the general workforce, 33.1%, and that's a low in 2024 compared to some of the prior years. So you can see almost 3 times the rate of what you see with federally mandated positive rates. So, you know, there's a good reason for everybody to say, why should we be, you know, very involved with and aware of reasonable suspicion and following it, looking for it in the workplace and taking action on it. That data speaks to itself. So overall, the brief kind of description of state laws and some of the things that are out there that companies need to be aware of, the different categories of state laws. Of course, there are mandatory and voluntary state laws in about 33 of the states, and 17 of those are mandatory and 16 are more voluntary related. The other states don't necessarily have mandatory or voluntary laws, but they have statutes and they have case law and they have other things that you need to be aware of in terms of conducting your drug testing. Case law, sometimes, you know, companies need to be particularly aware of that in certain states like California. There's a lot of case law out there, and you may have your overall program well fit and suited to the state laws, but sometimes it's important to take a look at the case law history too, to see things you might want to be including or not including in your policy. Workers' comp, unemployment compensation, there are industry specific laws. And then, of course, the big old category of medical and recreational marijuana that has begun to be such a big part of policies today and a big part of what's changing in the workforce over time, and an area that people really need to keep an eye on as regards to updating their policy, which really should be done at least, you know, once annually. It should be taken out and looked at, and maybe even if you're a company with a lot of moving parts and doing business in a lot of different states, that policy should probably be updated on an annual basis, or at least looked at for updates. So some specific states that we cover here in a few slides. For example, in Iowa, it is permitted to do this. There are always going to be some specifics around how you should be doing reasonable suspicion, spotting it and testing for it. I'm not going to read all the stuff here, but in general, The drug or alcohol testing needs to be based on evidence that employee is using or has used alcohol or other drugs in violation of the employer's written policy, and that is typically going to be, needs to be specific and articulable. These are two terms that are used pretty common in many states, that it's drawn from specific and articulable facts and reasonable inferences from those facts in light of experience, blah, blah, blah. So, and then there's some inferences giving here in terms of, you know, the observations, what you're seeing, whether it's smells, signs, symptoms, someone acting erratic and acting impaired. All these things get put together and say, we've got, you know, reasonable suspicion here. We need to take them on to the next step and conduct drug testing. In the state of Illinois, it's required, specifically in the public works area for contractors. Very similar language here, that there's a belief based on behavioral observations or other evidence sufficient to lead a prudent or reasonable person to suspect that an employee is under the influence based on different behaviors. And this is one where they also add that tidbit that it should be observed by more than one supervisory or managerial employee, and that it needs to be conducted by someone that's completed a certified training course. So that's for the state of Illinois and the public works area. Florida has a required law, and it relates to under their voluntary law. Again, that a belief that an employee is using or has used drugs in violation of the company's policy, and then similar facts to support that in terms of what they've spotted and how they're acting and how they're performing. All goes into it. And all this, by the way, should be being documented as you go along and you're talking to that employee. It's not just something you sort of commit to memory and maybe put it on paper, you know, a week or two down the road. It should be documented right away. California, it's permitted with some restrictions. There is talking about their case laws just a little bit ago, there's a particular case law here, the Superior Court of San Diego County. That's an important one related to reasonable suspicion testing. And this one says, if a drug test is not triggered by a reasonable belief the employee is intoxicated, the employee may have a stronger reason to expect to maintain his or her privacy, and the employer may have less need to demand the test. That's important. Okay, a few more slides. Kind of this one I think is really key when it comes to the drug testing methodology that you select and how it would tie to reasonable suspicion or potentially impairment testing. And it's important to note that one size doesn't necessarily fit all anymore when it comes to drug screening. Urine testing has been the standard in the industry for 30+ years, but now there are good options. And there are other ways to do it and ways to basically allow these types of methods to fit to the program. And for example, the short window of detection, I've got this divided into 3 categories. The shortest window of detection, that's going to tie best to suspicion, someone under the influence right now on the spot, is going to be those things that are like either the impairment screens that are coming onto the market. Oral fluid drug testing is a really good way for recent drug use. And there's a test for THC, a breath test for THC now, that's out there by a company called Cannabix, and Omega's Laboratories is offering this in the States. And so it's a way to do THC with a breath test that gives you that immediate window of detection, like within 2 to 3 hours. So you're getting very recent use with these methods. You're identifying impairment, particularly with the impairment screens, or under the influence with something like oral fluid. You're measuring the parent drug, which is important, and don't have time to get into it in this short webinar, but parent versus the metabolite is a very important distinction. And so this category 1 is really more associated with workday use. In the middle, you have urine screening, primarily oral fluid for some drugs, but these go out a little longer. So you're looking at weeks as compared to the first couple of hours or a day. You're looking more at what I would call recent to past use, not picking up the parent drug. In the case of urine, you're picking up metabolites. And so you're getting a little bit of work day, but more so past use. In certain states, that's not good enough. Now there are laws that require you to use a test for example, for THC, where you are testing for the parent or psychoactive form of the drug. So that's an important heads up in states like California and Washington. And then the longest one is really hair testing, where you're looking at months out to 3 months, or in some cases even more. So you really are looking at past use. You're looking at the metabolite, and you're really looking more at lifestyle, not necessarily what did they do today before they came into work, but what did they do 2 weeks ago, 5 weeks ago, a month ago. And so that's just important to keep in mind, to be able to then take that information and say, okay, what do I want to be using in what applications? For pre-employment testing, oral fluid, urine, and hair are all good tests. They're all good for slightly different reasons, but they certainly are applicable. When you look at random testing, almost all the methods are really going to be quite good. For post-accident though, and reasonable suspicion, you really want something that's picking up recent use, so you can make that correlation between your observation and the fact that they're coming up positive on a screen. So the impairment screens, oral fluid, the breath THC, if you're just looking at THC, those are really good methods for your reasonable suspicion and post-accident test. And then follow up, you're hoping that they've cleaned their act up, or if it related to substances, or they're coming back into the workplace. So you really do want to look at urine and hair, a little bit longer term indicators, as to what would be best for those applications. Coming toward the end here, where we can really help, I think, is in if you're asking questions about, well, how do I get state law information? We have a great database that tracks all that. It's up to date almost on a weekly basis, and we have subscriptions to that state law database. We do policy work, so if people are looking to have their policy updated, this is something we can do and do all the time, whether it's a review or a full update of a policy. And then we have online training courses. So we have reasonable suspicion. We have DER courses. We have signs and symptoms training, and we have all the DOT modals covered as well. And then there are some other things that we offer relative to our overall consulting and expertise in the drug testing field. Excuse me, this is kind of the contact information for myself and for upcoming sessions that we have. On the 13th, Bill will be doing one, and 27th, Jackie Prone will be doing one. And so let's move to some questions. Okay, so there is one question that came in relative to the window of detection chart that I showed, and deals specifically with THC and oral fluid testing. And the question was, is there a difference between lab-based and instant oral fluid tests when it comes to THC positive rates? And so I think the answer to that is, first and foremost, the two tests are somewhat different in terms of their overall windows of detection. The rapid instant tests are really good at picking up very recent use, like from the time someone uses or a few minutes after someone uses, up to about 8 to 10 hours. So it really ties nicely to that workday use. Laboratory tests for oral fluid THC can go out a little bit further, maybe a day. In some cases, I've seen data that would suggest even 2 days for lab-based tests. But and the reason for that difference is because there are different cutoffs that are used by these assays, and it's difficult to achieve the lower cutoff, which is 4 nanograms per mil THC that you can hit with lab-based testing. It's difficult to achieve that with an instant test. And so most of those screens, the rapid screens, are a little higher on the cutoff, which is why you don't see out past, much beyond 8 or 10 hours, which is good for those that are trying to really zero in on that workday use. And so that's the answer to that question.
Okay, thank you, Brian. And thank you to everyone joining us for today's edition of Current in 30. We hope these insights help you stay informed and confident in your workplace drug screening decisions. As a reminder, this presentation was recorded and you will receive instructions in a few days informing you how to access the recording via email. Additionally, this presentation qualified for half of a professional development credit from SHRM and HRCI for those who attended today's presentation in its entirety. If you have met that requirement, you will be emailed the activity IDs. Remember, we'll be back every second and fourth Monday of 2026 with new things you need to know. Be sure to follow the Current Consulting Group and check your inbox for upcoming session details. Until next time, stay current and have a great day.